Chapter 20. Other kinds of commercial paper. Section 210. In general, among the most common species of commercial paper other than bills of exchange, promissory notes and bank checks are bills of lading, certificates of deposit, certificates of stock, coupon bonds, drafts, due bills, letters of credit, paper money and warehouse receipts. Section 211. Bill of lading. A bill of lading is an instrument issued by a common carrier to any person desiring to have goods transferred from one place to another. It contains a receipt acknowledging the receipt of the goods and also an agreement to carry them to a certain destination to a party designated in the instrument as the consignee. It should contain a description of the quantity and condition of the goods received, the marks on the same, the names of the consignor and consignee, the place of shipment, the place of discharge, and the price of the freight. The bill of lading is generally issued in sets of 3 and sometimes in sets of 4, yet there need not be more than one copy as the number is immaterial. When issued in sets of 3, one is retained by the common carrier, a second by the consignor, and a third is to be sent to the consignee. A bill of lading in the strict commercial sense of the term is not negotiable in like manner as bills of exchange and promissory notes. Yet they are assignable by endorsement and pass from hand to hand as other negotiable instruments. It differs from the promissory note, bill of exchange and check, in that it calls for a delivery of goods instead of the payment of money. It is held that goods shipped by a bill of lading drawn to the order of the shipper may be transferred by delivery of the bill without endorsement. The character of bills of lading is now regulated in many jurisdictions by statute, and in some, bills of lading are declared to be negotiable like other commercial paper. If the consignee has received the bill of lading of the goods, deliverable to him or his assigns, or endorsed to him or his assigns, and endorsed it to a bona fide third party, then the vendor's right to stop the goods in transit and hold them as security for the purchase money is defeated, and the assignee of the bill acquires as perfect a title to the goods, although they have not reached the buyer's hands, as if they had actually passed through his hands and been delivered bodily to him. Sometimes for the protection of the vendor the bill of lading for the goods shipped is sent to the vendee, attached to a bill of exchange for the purchase money. The purpose of this is to make the passing of title to the goods contingent upon the honoring of the bill of exchange. Section 212. Certificate of deposit. A certificate of deposit is an instrument in the form of a receipt given by a banker for a certain sum of money. When the time of payment is specified and the words of negotiability are used, it is in effect, then, a promissory note. Otherwise it only circulates as a negotiable instrument by assignment. In general, negotiability of such an instrument depends upon its wording and is controlled by the same rules that govern promissory notes. The certificate of deposit is used instead of drawing a check on the fund deposited, whenever the depositor desires a continuing security, drawing interest, and payable on demand or at some time in the future. A certificate of deposit is prima facie a conditional payment only if transferred in payment of a debt. Section 213. Certificate of stock. A certificate of stock is a simple certification that a certain person is the owner of so many shares of stock of the company mentioned. It is signed and sealed by the president and secretary of the company. It is not the stock itself but only evidence of the stock, and not money, therefore it is not as fully negotiable as a promissory note or check. The certificate is passed from hand to hand by assignment of the certificate, and by the rules of most corporations there must be an assignment on the books of the company in order that the person holding the certificate may be entitled to all the rights of an owner of a certificate of stock in the first instance. The general rule is that the purchaser of the certificates of stock gets no better title than his vendor had. And if stock which is payable to bearer or endorsed in blank is stolen or found, and unlawfully transferred to an innocent purchaser for value, the real owner may nevertheless recover it. Section 214. Coupon bonds. A coupon bond is a primary obligation, in the nature of a promissory note, promising to pay a sum of money on a day certain in the future, to which are attached certain other obligations called coupons, or interest certificates, and of which there are usually as many as there are payments to be made. In their form they usually resemble promissory notes more than they do bank notes, checks or bills of exchange. They are fully negotiable if they contain words of negotiability. Each coupon is in itself a separate instrument containing a distinct and independent promise to pay the sum named. The holder of a coupon bond does not necessarily have to own the bond to recover on the coupon, and he can sue on the coupon without producing the bonds to which they were attached. They are issued by the federal and state governments, by municipal and other public corporations, and by all sorts of private corporations, such as railroads, canal companies and the like. The negotiable instruments law in some states has the following provision. The owner or holder of any corporate or municipal bond or obligation, except such as are designated to circulate as money, payable to bearer, heretofore or hereafter issued in and payable in this state, but not registered in pursuance of any state law, may make such bond or obligation, or the interest coupon accompanying the same, non-negotiable, by subscribing his name to a statement endorsed thereon, that such bond, obligation or coupon is his property, and thereon the principal sum therein mentioned is payable only to such owner or holder, or his legal representatives or assigns, unless such bond, obligation or coupon be transferred by endorsement in blank, or payable to bearer, or to order, with the addition of the assigner's place of residence. Section 215. Draft by bank. It is customary in the transaction of banking business for one bank to issue drafts upon a bank located in another state. It has been decided that such drafts are checks and the parties thereto are subject to the same liabilities and possess the same rights as though such drafts were drawn upon a particular bank or banker by an individual. Section 216. Due bill. A due bill is an instrument whereby one person acknowledges his indebtedness to some other party in form as follows: due be $200, payable to his order, signed A. Thus it is in substance a promissory note. If the bill contains words importing a promise to pay and rendering the instrument negotiable, it is generally treated as a promissory note. Some jurisdictions have by statutory enactment extended the law of bills of exchange and promissory notes to all instruments in writing whereby any person acknowledges any sum of money to be due to any other person. Section 217. Letters of credit. Letters of credit, sometimes called bills of credit, are open instruments of request from some person, usually a merchant or banker, to any other person to advance money or give credit to some third party and promising that he will repay the same to the party advancing it or will accept bills drawn upon himself for a like amount. If addressed to some particular person, that person alone can advance money upon them and then recover of the writer. But if they are addressed to any person in general, then anybody can advance money upon them and recover of the writer. Bills of credit are usually issued by banks or merchants. These letters are often used by travelers and agents to obviate the risk and burden of carrying about money. In such cases a deposit is made by the bearer of the letter with the banker as an indemnity. Section 218. Paper money. Paper money in its most common form is that of United States Treasury notes, United States silver and gold certificates and bank notes. United States Treasury notes differ very little from promissory notes payable on demand except as to the texture of the paper on which they are printed. The purpose of the quality of the paper used is to prevent counterfeiting. Treasury notes differ from other paper money in that they have been made a legal tender by the federal government. Gold and silver certificates circulate as money. They specify on their face that there has been placed or deposited in the Treasury of the United States a sum of gold or silver as indicated by the certificate, which is payable to the bearer on demand. These certificates are not a legal tender. Bank notes are the promissory notes of an incorporated bank and are intended to circulate as money. They are not legal tender, but may be tendered in payment of debts the same as other money. If not objected to, they are payable to bearer on demand and are negotiable. It has been held that a bona fide holder can compel payment to him although they are proven to have been stolen from the rightful owner. The mere possession of the note is prima facie evidence of bona fide ownership, and this presumption is so strong that it cannot be overturned by showing the holder was negligent in taking the notes without inquiry. All that it is necessary to show in this connection is that they were obtained in the usual course of business. The payment of bank notes is secured by the deposit of government bonds, and the banks issuing them being so closely supervised by the government, They circulate without regard to the banks which gave them life. The financial standing of the national banknote differs in nothing from the treasury note, except that the treasury note is a legal tender and the banknote is not. Section 219, Warehouse Receipt. A warehouse receipt is a receipt showing the acceptance of grain or other goods which are to be delivered to the bearer. As to grain, upon its receipt by the warehouseman or elevator company an instrument is issued which sets out that a certain quantity of grain and kind has been received and a promise is made to deliver it to the order of the depositor. Such warehouse receipts are taken by the depositor or the exchanges of the cities as the representative of the grain itself, and when the latter is sold the receipts are transferred by endorsement and delivery, or by delivery alone. In such manner the title to the grain will be transferred just as if the grain itself had been delivered. These receipts represent goods and not money, and so are not negotiable as promissory notes and bills of exchange.